Well, good afternoon, everyone. Thank you so much for joining us. I'm Matt Vallière. I'm the Executive Director of the Institute for Patients' Rights. We're an organizational plaintiff in the two lawsuits we're here to discuss, and I'll be your host today. For the benefit of some of our friends with disabilities, I'm an early 40s man of color, dark wavy hair, short cropped dark beard, olive complexion, wearing a black suit with a white button-down shirt, black and blue square design tie, and I'm in front of a flower print background. Our broken medical system is driven by a profits before people structure. People are not getting the care they deserve, and choices are often artificially limited by financially motivated players. Too often, medical professionals and society on the whole view life with a disability as less worth living, less worthy of care, scarce medical resources, and healthcare dollars, better off dead. We have four panelists here for you today who will provide our position, purpose, and the arguments in the cases we have filed in district federal court to permanently enjoin both Illinois' and New York's assisted suicide laws. These are two separate lawsuits that were filed on the same day last Thursday. So enjoining in legal speak just means to stop them from implementing the law completely. It's a sort of way of overturning the so-called end-of-life options acts in each place. These are assisted suicide laws. We argue that these two statutes violate federal anti-discrimination law that protects the rights of people with disabilities and as well as a violation of the U.S. Constitution. So we have with us today Michael Bean, who's the co-founding partner at Rosenbein, Galvin, and Grunfeld, one of the top firms for constitutional healthcare, disability rights, and mental health care for prisoners. Mr. Bean concentrates his practice on complex litigation, class actions, constitutional and civil rights law, disability rights, and attorneys' fees disputes. We also have Jose Hernandez. Jose is from New York, and he's been profoundly shaped by his own family's experience with illness disability. As a teenager, Jose experienced his mother's fight with cancer, and he may talk a little bit about that later. He himself has a spinal cord injury and is a member of organizational plaintiff United Spinal. He too is an individual plaintiff in the lawsuit against the state of New York. We also have Dr. Nooshig Salvador. She's a palliative care specialist. During her career as a physician, she's worked in the inpatient, outpatient settings, both in academic and corporate worlds. She herself is an individual plaintiff in the lawsuit against the state of Illinois. And finally, we have Ebony Payne. She is from the South Side of Chicago and a member of Humanized Long-Term Care Campaign, Consumer Voice, United Spinal Association, ADAPT Chicago, and several other organizations. Ebony also has spinal cord injury as an individual plaintiff in the lawsuit against the state of Illinois. And she is, as I mentioned, a member of United Spinal and an ADAPT organizer. So ADAPT and United Spinal are both organizational plaintiffs in the lawsuit against the state of Illinois. So I thought we could start out with, well, I should go over a bit of the housekeeping items. So just to make clear, we take all questions via the Q&A function. If you move your cursor around a little bit, you'll find the toolbar at the bottom. Sometimes the Q&A function shows up right there in the toolbar. It's a bubble with a question mark in it. It says Q&A. If you don't see it, click the More button all the way to the right. The three dots in it should show up there. Please, if you are from the press, list the outlet that you're with and your name as well. It should show up, but that way if you have a question for a specific panelist, we can make sure that that gets answered. For any further media requests, please contact Meg Tully at mtully@apcoworldwide.com. The session will be recorded and we'll share a link on our platforms afterward. That's the End Assisted Suicide platforms. Panel and host, for anyone who's not speaking, please keep your mic on mute. And finally, if you can benefit from closed captions, again, move your cursor. You should see the CC button, Show Captions. If not, you again click the more and it will provide the opportunity to show captions. There's another button in the upper right corner of the show captions button that allows for you to adjust the settings for the captions. And just to make sure that you know that for those who can benefit from ASL interpretation, that should be visible on your screen. Okay, that was a lot. Sorry. So I want to start out by asking our lawyer, Mike Bean. Mike, you've been with us for some time, working on a handful of lawsuits in federal court against similar laws as those in Illinois and New York. Could you just start us off by setting the stage? What do these lawsuits argue? Are there any differences in the New York and Illinois lawsuits comparatively to the other three against the states of California, Colorado, and Delaware? What does this coalition of organizations and individuals hope to accomplish legally? And how do these suits dovetail with the ones we just filed on Thursday, dovetail with the ones we already filed? And do you have any sense of time frame on the overall strategy? I know that's a lot of questions, but I figured you could handle them all at once.
Thanks, Matt. I'll try to briefly go over this, and of course, we'll be glad to answer more detailed questions. The first lawsuit filed was against the state of California, and that was filed in April of 2023. In that case, United Spinal Association, Not Dead Yet, Institute for Patients' Rights, along with Communities Actively Living Independently and Free, an independent living center in Los Angeles, along with two individual plaintiffs, Lonnie Van Hook, who unfortunately has passed on, and Ingrid Tischer. That case is now on appeal in the Ninth Circuit. It's been fully briefed and argued, and as unfortunately I've told my clients, it's very difficult to predict when the Ninth Circuit will rule. The case was held up in light of other cases pending in the Ninth Circuit that may affect the case. Colorado challenge was filed in June of 2025, about a year ago. That case is still pending in the district court. And a similar group of national entities, along with an individual plaintiff, Mary Gossman. An addition there was the ADAPT group, called Atlantis ADAPT. And that case brings similar claims as were brought in California. And the final case filed before these two cases was in Delaware in December of 2025. There again, we had some of the same national organizations, along with a Delaware chapter of ADAPT and several independent living centers. And we also had the National Council on Independent Living joined in the Delaware case and is also a plaintiff in both the New York and Illinois cases. That case is on appeal in the Third Circuit Court of Appeals. It's fully briefed and is expected to be argued in the fall. The date has not been set. In each of these cases, as Matt mentioned, we are putting together a disability rights-based challenge under the ADA and the Rehabilitation Act and the Affordable Care Act to these laws, which provide for medically assisted, in most of the case, physician-assisted suicide, although in some of these states already, non-physicians are allowed to be the provider. The disability rights community sees these statutes as violating the ADA and the related disability statutes along with the United States Constitution for a variety of reasons. Fundamentally, it treats their lives differently than everyone else. So, for example, if a ably appearing person walks into a doctor's office and expresses suicidality, they can expect to be met with treatment and referral for mental health care, suicide prevention, to address whatever problems, issues they're addressing that are causing them to have these symptoms, which are known mental health medical symptoms that are common in human beings. Yet under this law, one can be referred rather than to treatment. The doctor will assist you in obtaining lethal means, a lethal prescription, and provide a whole different system that is a fast, efficient track towards death for people with disabilities. This is a dangerous system in our environment today, where so many people have denied or delayed medical care, access to supports that they need to live freely and independently in their homes, long waiting lists for home health care aids and modifications, the kinds of things that Ebony and Jose can talk more about and experience so much better than I can speak. Their experiences with autonomy and choice are very different than what these laws express. In other words, we're told that these laws give people choice and freedom to make decisions about their life. But what we see, and the people, my clients see, is a choice of committing suicide or waiting or fighting for the care that they actually need to live freely and independently. There is no requirement in these laws for actually making sure that the person has what they need to make the choice for life, to live freely and independently. We think that is what the ADA and the Rehab Act and the Affordable Care Act mean when they prohibit discrimination against people with disabilities and systems by the state that discriminate against people or set up a separate and unequal system for people with disabilities. That's what this is, and that's what these lawsuits call out. And I think I'm going to stop there unless you have another question, and we can talk more.
Just, do you see were there any differences between those previous 3 lawsuits and those that we just filed in Illinois and New York?
I think one difference is that we have Dr. Salvador as a plaintiff in Illinois. This is the first time we've had a doctor as a plaintiff. We have had tremendous support by the medical community for our position, but we have not used a doctor as a plaintiff. We are also focusing in both New York and Illinois a little bit more on the fact that the law harms and discriminates against people immediately upon its going into effect. In other words, if you're a person with a certain level of disability, where you might be perceived by a doctor as being eligible under these laws, you're immediately discriminated against. In other words, these laws harm you on the day that they go into effect, which um, is August of this year for New York and September for Illinois. Um, and I think that's a little, that's true also for California and Delaware, but and Colorado. We didn't make that perhaps as clear as we could have. I think it's a focus on the idea that you are treating me differently and you're discriminating against me merely by putting me in this category where if I have a bad day and I'm in with a doctor and I'm expressing um, some true feelings that might be depression, despair. I have some challenges, just like any other people. That because of these laws, I am at risk of being steered to suicide, and these laws put me at risk on the day they're enacted. And I think we're trying to make that more clear to people that um, there aren't a whole series of events that must happen before there's harm. The harm happens from day one.
Yeah, I think that's super important. It's super important to recognize that the primary harm in that sense is not being put at risk of deadly harm. It's the discrimination itself. And discrimination is a harm. And it's a harm that can and has in the past, and we hope will nullify this terrible law,
Yes.
as those sorts of claims have done with other public policies. Well, thanks for laying that out for us, Mike. Ebony, I was hoping that you wouldn't mind just telling us a little bit about your personal situation, your personal story. What concerns you most about the legalization of assisted suicide in Illinois, given those realities that you face on a day-to-day basis? You're on mute currently. Just 1 second, folks. Okay,
Sorry about that. I had to get some help.
not to worry.
Um,
Thanks.
so I'm a quadriplegic, 43-year-old African American woman. My personal experience with assisted suicide, and this wasn't even assisted, but it happened way before the bill came into play. I was in the hospital. I had very bad infection. It was so much, maybe a double or triple infection. And the doctor kept having to intubate me. It got to the point where they did not want to continue to intubate me. And he told my family member, well, we can give her something to help her relax, and you can just let her go. That was the first instance. The second instance was I said out of my mouth to just kill me. And I had a very bad infection.
Who did you say that to?
It was a group of people in the room, including doctors, family members.
Were you in the hospital at that time?
I was.
I see.
I was. And I think it was the fact that on some level of consciousness, I was just done with the entire process. And it's dangerous. It's very dangerous. Because the first time that when the doctor told my family member, well, we can just give her something to help her relax and you can let her go. it wasn't the first time that I heard that. I heard him say that to another patient's family member. Um, when you're a person who can't do for themselves and can't move and can't get out of the situation, it makes it 10 times worse. What was the other question? I'm sorry.
Just, you're an individual plaintiff in the Illinois lawsuit. So it just, you know, your concerns about the legalization of assisted suicide in Illinois, given the realities that you face. I mean, obviously with some of the experiences like that, where medical professionals have devalued your life and just thought that it suggested your family to let you go instead of trying to continue to save you. And then similarly, like the demoralization, you felt at that moment when you asked them to help you die before it was legal to do so. What would your concerns be given those realities now that, we're staring down a barrel of assisted suicide going into effect in Illinois in a couple of months?
I think that it will make me concerned that people would use that as an excuse or just a reason not to try and not to look for solutions to whatever medical situation is going on. Like I stated before, it's dangerous because now there's a way out for doctors and they don't have to first do no harm. They can just simply say, well, they told me. And even though they say there are things in place for them, it has to be months and it has to be evaluations. It has to be this and that. I don't think it will be a hard thing to get around.
Yeah, it's certainly not months. I mean, the waiting period in the Illinois law is very short. And if somebody decides they're gonna circumvent even that supposed safeguard, there are no repercussions.
And that's a large part of it as well. Their insurance will go down. So they don't really have something that will hold them accountable. To say you have to be responsible. You have to execute everything above board. You, in order to continue to practice medicine. They won't have that anymore.
Mm-hmm.
The whole do no harm is out of the window because what's the purpose in standing up and taking that oath when, okay, whether I say it or not, I don't really have to.
Yeah. I mean, it terrifies me that because that principle of do no harm's out the window, you may or may not get the same suicide prevention care and services as everyone else. That friends of mine could die by suicide with the help of medical professionals, those same people who in non-legal states would be obliged to initiate suicide prevention care. Instead, now because the person has life-threatening disabilities, now they're off the hook for all that liability, professional, civil, criminal. So, well, thank you, Ebony. I appreciate that testimony and your appreciation. I mean, I just am over the moon that you were open to being a part of the Illinois lawsuit as an individual plaintiff. Your story is just so powerful and grateful for you. And I want to just bounce to Dr. Salvador. She apologizes not able to be on screen with us today, but Dr. Salvador, could you just talk a little bit to Ebony's point about do no harm being out the window? What does that look like for doctors and medical professionals across the board, especially like, you in your palliative care and hospice discipline? How do you see assisted suicide laws affecting that oath, and how will this law impact your ability to practice medicine?
Thank you for asking. Can you hear me well? Because I am driving.
I think if you speak up just a skosh, then you'll be fine.
Okay. So my definition, ever since I was called to this profession, being a healer as a physician, yes, I took an oath that basically stated that I would not give any sort of lethal drug to any individual who requests it, nor would I make a suggestion of it. So that's the first thing in terms of that oath at my graduation from medical school. My definition of being a healer as a physician includes those of first doing no harm, that of beneficence and non-malfeasance. And unfortunately, in my career, my experience is such where I have had individuals who, out of shock, sadness, despair, anxiety, depression, when they hear a life-limiting diagnosis, it's very scary for them. And one of the things of which they might pursue or ask about is something like with assisted suicide. What I have found in my experience is that when we develop a relationship with our patients, one of compassion, one of love, to really get to know the fears, the anxieties, to be there with them, walk with them and their loved ones, what I have found is that our patients then will say, well, I want to live as long as I can without having to suffer through this diagnosis, without having to suffer through what happens in the trajectory of this diagnosis. That's why, as a palliative care specialist, I strongly believe that if we were to have access, pure access for our patients who go through this kind of suffering, with chronic disease, with life-limiting illness, with anything of which they are diagnosed with that involves the need for palliative care, we do not have to go down the road to request assisted suicide. One thing that I find very disturbing as a physician is that I may be asked to give a suggestion as to go where for the patient to go, since I may have a moral objection to this. Well, by making that suggestion, I still go against the oath that I took. The other thing that I want to say is that concerning first and do no harm, when we look at countries like the Netherlands, where the laws have passed for assisted suicide about 20 years ago, we have to recognize that laws evolve the way generations, people, and systems and culture evolve. That now in that country, just several years ago, euthanasia has now become acceptable for doctors to take the life of infants with particular diagnoses, including individuals who are considered mature minors up to 12 years of age. So these safeguards that have been placed are not really safeguards. This is a blind way of looking that safeguards will stay permanent and 100% throughout time, and this is not true. So we have to take all these things into consideration, that assisted suicide, with, if anything, will do great harm for society if the opposition will say, will not happen now. if we dare to say something like that, it will happen in the near future.
Yeah, I think
I
that,
hope that answers your question.
yeah, I think so. And I think that, you know, as you mentioned, the slippery slope, you know, Mike and I will sometimes be chatting privately and it's just like the slope has already slipped. I mean, like they just will interpret the law however they like. And they help, you know, somebody who's perfectly physically healthy to kill themselves because they're they choose to voluntarily stop eating and drinking in order to qualify for lethal drugs under the law. Or you have doctors who are helping young people with eating disorders to die by assisted suicide in some states. So these are stretching the what it says in the law already without changing the law. And that's also a very sharp concern in
And I
terms of
think
the
that's important to um, highlight here. People always look at other countries and say, this is where it might go. We might allow people with mental illness to to commit suicide, and the American laws don't permit that. There's nothing in any of these laws that prohibits people with mental illness from uh, receiving assisted suicide. And in fact, we know that people with serious mental illness do receive assisted suicide. And as Matt just pointed out, in our Colorado case, we've pointed out that Colorado physician specializing in eating disorders has herself created a new diagnosis called terminal anorexia and has provided uh, physician-assisted suicide to a series of young women. This is not disputed. It's in a published paper and has been debated in the uh, professional community because other specialists in treating people with eating disorders disagree strongly that this is a terminal diagnosis. Um, but the laws, both in Colorado, Illinois, New York, um, allow for this kind of discretion by doctors. There is nothing more in any of these laws that would limit providing assisted suicide for eating disorders. That's permitted under all these laws. Uh, and uh, it's not maybe what people envisioned,
right.
but it is already happening in the United States, and there's nothing in the Illinois law or the New York law that would prohibit it from happening in those states. And by the way, this as we understand, this doctor is also licensed in Illinois and New York. So you know this is something that is real now in the United States under these laws. It is not. You don't have to wait for a slippery slope.
Thanks for clarifying that, Mike. Jose, I'd like to turn to you. Just what made you decide to get involved as an individual plaintiff in the lawsuit against the state of New York to overturn the assisted suicide law there? And maybe you could tell us a little bit about the changes, how the changes in the services landscape, including that to CDEEP, and maybe just a brief explanation of what that is, may impact the disability community with assisted suicide in the books in New York.
Yeah, so can you hear me? All right, good. So, yeah, my name is Jose Hernandez. I was paralyzed due to a diving accident when I was 15 years old. And a year after my injury, I was threatened to be placed into an institution. That'll come into full context when I speak about the CPAP program. But the reason why I got involved is my mother, in a sense, when she was 28, was diagnosed with stage 4 ovarian cancer. And she was given a 6-month diagnosis. Um, Thankfully, assisted suicide medication and laws weren't even thought of back then. And it wasn't available. Doctors and her insurance company did everything they could to preserve her life, and she lived 13 years. 13 years. Put that into perspective. If assisted suicide laws were passed back then, my mother would have chosen to end her life. I would have lost my mother when I was 8 or 9 years old. I would have missed out on 13 years of, home cooked meals, 13 years of good nights, 13 years of having my mother around to make me the strong man that I am today. So that's one of the reasons, the science behind diagnosing is imperfect, and we should try everything to preserve life and extend it as long as possible. I couldn't imagine committing suicide or asking for assisted suicide drugs, uh, especially now that I have a 2.5-year-old. And I want to see him grow as long as I can. Um, Now, for people with disabilities in New York, there's been so many changes with our services, right? Last year, the in September, they cut the eligibility requirements. So you need uh, more. There's more stringent requirements to even qualify for home care services. They also switched 250,000 consumers in New York from who are in the CDPAP program. CDPAP is a program where I hire my own home care workers. I train them. I ultimately fire them. I have to do all of the process myself. So I had a service provider that paid my home care worker, and the governor upended 600 or 700 companies and uh, provide care through one company. But that company isn't really doing its job. There's a lot of lapses in pay, or um, it's not the same structure. So, for many people who are in that program, they either fell out of the program or go on without care, or um, left the program or went to traditional home care themselves. In New York City, they're also trying to pass a law that would limit home care workers to working 12 hours per day, which again would jeopardize the home care. People with significant disabilities need to stay in the community. Um, it just seems to be getting worse. All the services that we need are being cut. All of the supplies that we need to live just a life in general are being cut. So I said I was threatened to be placed into a nursing home. With all of these service cuts, we're one step away from being placed into a nursing home. And a nursing home is a place that many of us fear. And what we say is we prefer to die than be placed into an institution. So if I was to lose everything, it would be a difficult choice. Either be imprisoned in a nursing facility by no choice of my own, or um, in a sense, uh, are they going to start offering me assisted suicide drugs so that I don't go into a nursing facility and don't have to provide me the services I need to get out of a nursing facility? Is my health going to degrade while I'm in the nursing facility? It's just not good. Society in general views people with disabilities as burdens. And I'm sorry, Ebony, that you experience what you experienced in by a doctor's hand. If a doctor himself can say to a family member that loves me, hey, let them go. What does that say about society? It's too easy to dismiss people with disabilities and make it a lot more easier for us to make that choice of assisted suicide instead of choosing life. I'm like,
Yeah, so
thankfully, I live a pretty good life. I work, I get around, I try to take care of my 2.5-year-old son as best as I can, and I want to see him have a beautiful life. But society definitely makes it difficult. Even when me and his mother, who also has a disability, roam around the world with him, we are judged. She has been told by people in the streets, I can be a better mother than you. And my son has everything he could ever want and more love than many people have on this planet.
Mm.
But it's that societal pressures that make it difficult for us to even live.
And I think I mean, what we often hear is like, oh, this isn't for people with disabilities, it's for people with terminal illness. You know, what when so many people with disabilities qualify under the law because of their services being cut, because of barriers to access to the sorts of things you're talking about. I mean, like if somebody who needs home care doesn't get home care, they become terminal. That's how that works. And if you terminal, quote unquote, under the assisted suicide law, giving 6 months or less to live, many people who are in the disability community, whether it's they have diabetes, they have spinal cord injury, if you need breathing support, nutritional support, etc., these are things that without which um, you can access assisted suicide, and that when the society is putting all that pressure, there's so much pressure, and the demoralization that can occur when at every turn, like, oh yeah, you just let her go. I had a friend is a quad who was told, oh well, you can forego care if you want to. It was for a urinary tract infection. He's like, how about you give me the antibiotics? How about that? Like, what are we even talking about? But no one would ever say that to a non-disabled person. And it's the same thing with assisted suicide laws. There is going to be both implicit and explicit pressure on people with disabilities to check out. And that's no one should have to endure that. And with that, I think it would be a good idea to turn to some of the questions with the last 15 minutes that we have. Liza Citron asks, and I think this is a great question. I think it would be helpful to go through it. What are our thoughts? What are your thoughts, she asks, on how this becomes complex for individuals who have short-term terminal illnesses? She says, for example, cancer that is almost certainly going to end in death within 6 months does not want to slowly decline and go through pain and isolation. Do you think there's a way to keep what you are arguing in this lawsuit while still making a line that is available for those who are in short-term terminally ill situations, so that they don't have to go through a slow decline and pain? The question is certainly open to the whole panel. Mike and you and I have talked about this quite a bit, so it may be
Yeah.
worth your taking an initial stab at it.
Well, first of all, we understand the experience that people have had and want to avoid um, in the circumstances described by the question. And we know that access to quality palliative care and hospice is not always available. We join all these organizations, and the plaintiffs join in advocating for more resources and access to quality palliative care and hospice care for people who are at the ends of their lives, so that they can um, uh, uh, go through that transition in an appropriate environment. No one wants to die in a hospital. No one wants to die in pain. And we understand, and Dr. Salvador can address this more professionally than I can, that um, in almost all cases, patients can be made comfortable for that final period of their lives. There aren't guarantees, but I do think that the idea that one must go through a period of isolation and suffering would be offensive, but the solution is not facilitating suicide. The solution is facilitating access to quality palliative care and hospice.
Yeah, so she clarified her question further down that for reference, she said, I'm referring to someone who refuses treatment because they've already been through it and already know how treatment makes them feel and it's not worth it to them. I get it is likely different for people who are receiving treatment. So I want to speak a little bit to that because you can't know every single circumstance perfectly. And I'm not going to speak to all of them in a blanket way, but there are life-threatening disabilities and what many people would call a quote unquote terminal illness that is not terminal if you receive the treatment. And people on the proponent side of assisted suicide, the ones pushing for this, it's like, oh, this is only for terminal ill people, only for people who are already going to die no matter what. It's not true. That's absolutely categorically not true. And so this particular person who, Liza, you're referring to, who's tried it, my own father-in-law, he said, I've had enough. He had 2 brain surgeries, chemo, radiation. They were offering a 3rd brain surgery. And he said, no, I'm just going to go home and enjoy the time I have left. And I don't think anyone here is advocating against that sort of thing, to provide somebody lethal medication instead of accompanying them with high quality, multidisciplinary palliative and hospice care seems like it's problematic when allowing for assisted suicide in some narrow circumstance, as you described, is not what's being proposed here. So we don't, I would just argue that there is no assisted suicide law that has ever been proposed that does not inherently discriminate against people with disabilities. People who have cancer itself is a disability. All of the diseases that underlie a 6-month or less prognosis are disabilities as defined by the ADA. You can't provide this in a way that is non-discriminatory, at least as it's been proposed and as we've seen it. So we're not here to figure out, how proponents can make a law that's non-discriminatory, but we can say for sure that every law that's been proposed, as far as I've seen worldwide, has it's always driven by a fear and loathing of disability. So I'd like to move on to the next question. Unless Dr. Salvador, I don't know if you have more to say about that. I don't want to cut you off. Nope. I think she's good. So I want to ask this question from Rose Mims. Will the impending lawsuits have any impact on other states that have existing assisted suicide laws if you're successful? And is there any suggested legislation or amendments that should be considered in statutes, in statute in states like mine, Arkansas, that prohibits physician-assisted suicide?
Right. I guess I will just say that if a higher court or the appellate court's rules that one of these statutes is violates the ADA or is unconstitutional, that would be a precedent that would be brought to bear or could be brought to bear in other states. The statutes in all the United States are based on the model set by the Oregon law, which was the first one in America. The other statutes, though there are differences, are basically the same structure of providing immunity from criminal or civil prosecution or medical board review or peer review for doctors who would otherwise be violating the standards of medicine and the penal codes in most states that prohibit assisted suicide. So if the structure of these laws was found to be a violation of the ADA, as we think it is, or the Constitution, as we think it is, then that precedent would apply to states that are not presently subject to these cases. Some would have to. It's not automatic, but we think that, especially if the decision was from the Supreme Court, uh, uh, all the laws in all these states would could fall. Again, it really depends on what issue is decided, and I can't really talk about the specifics. But because the laws are very similar in their structure, if this structure of law is determined to be an ADA violation or a constitutional violation, then it could rapidly apply to all of the American laws.
Thank you, Mike.
Mike.
Yeah, I think I'll talk a little bit to the second part of the question. I mean, is there any suggested legislation or amendments that could be considered in statutes that in states where assisted suicide is prohibited? I mean, certainly there are model palliative and hospice care statutes that help to provide additional funding, training, and understanding about how hospice and palliative care. I think those are worthwhile pursuing. There's some legislation that would bolster the rights of people with disabilities in different ways. But if assisted suicide comes to your state, a state law that's passed would have to supersede laws that are on the books, and if they're at conflict with one another, then the legislature would have to sort that out. So these are the things, but I think, having strong patient protections for people with disabilities in your state, if those protections are not currently there, are a good start. I wanted to also ask this question. John McNulty asks, do you think the opposing counsel will challenge the suit on standing grounds? If so, what is the strategy to argue that standing exists? So for everybody else who's not a lawyer, as I'm not one, I had to learn some legal speak, and standing is just, it's an idea in the courts that you have actually been harmed by the thing you say is a problem. So we're arguing that assisted suicide laws in Illinois and New York harm us. And so we have to prove that this group of people or this group of organizations has indeed been harmed by the law, or at least that harm is imminent. So, Mike, maybe you could talk about our strategy on standing.
Sure. This has been argued, and we anticipate that it would be argued again in Illinois and New York. We have the federal court in California found that our organizational plaintiffs did have standing to challenge the California law. And we are confident that we have met the requirements for standing for both our individual plaintiffs and our organizational plaintiffs in all of the cases. I do think that that standing is a complex issue. There's a lot of discretion in the courts as to how they address standing. We have a variety of different kinds of plaintiffs and a variety of different experiences in order to help get over that hurdle, because it becomes, unfortunately, a hurdle, because if no one has standing, then the law is never really tested. And there is a legitimate function in our system of government whereby the constitutionality of a law should be tested by the courts, and you should have a way of bringing to court a challenge to a law that you believe is unconstitutional or discriminates against you under the disability laws. So we understand that this is a challenge, but we believe we've addressed it.
Thanks, Mike. We're coming to the end of our time. I'd like to just invite Ebony and Jose to close out with any final thoughts that you might have before we close out the webinar, and just from your own personal experiences or thoughts about the conversation today.
I just want to say that, you know, at one point in this country, we valued life and fought for every breath that we have in our bodies. I don't know when the turning point was, but now it's becoming easier to request assisted suicide drugs than it is actually to get psychological help to prevent you from ending your life. And unfortunately, these laws need to be stopped, because if one life is lost needlessly, is one life too many.
Thank you, Jose. Ebony, any thoughts?
I agree wholeheartedly with Jose. And until this law is overturned, changed, look out for your loved ones. Make sure, if needed, that they have the medical power of attorney. And check behind the doctors, the nurses, the social workers. Read everything to the letter. Because that is where you will catch the fault in this law.
Thank you, Ebony. And we're at the hour. We're going to keep these lawsuits going. We're going to fight like hell for the living, as Diane Coleman used to say. Diane Coleman is the founder of Not Dead Yet, now run by Ian McIntosh. These lawsuits were Diane's idea, so we're just good stewards of her her work and this effort to abolish assisted suicide once and for all. For any additional information that you're looking for, you can find most of it on endassistedsuicide.org. We'll try to answer the remaining questions in email format, and you're welcome to follow up with us as needed. Again, this session was recorded, and it will be posted on the YouTube channel of the End Assisted Suicide Coalition group. So thanks again for coming. Thank you to the panelists, Ebony, Mike, Jose, Dr. Salvador. Thank you all so much. And we'll keep doing what we can do to protect the rights and the lives of people with disabilities with these lawsuits and otherwise. So take care, everyone. Have a great afternoon.